Good morning and welcome to the fourth in our series of autumn webinars. The topic for today's discussion is pricing conduct on big tech platforms and the role and limits of competition policy. Our principal presenter today is Neil Dryden, who's an Executive Vice President of Compass Lexecon and based in London. Neil was also the Competition Commission's expert witness in the recent and seminal case on predatory pricing in South Africa, where the Competition Appeal Court recently gave judgment. It was on the 19th of March, and that's the Media 24 case. Predatory pricing in South Africa is at the moment quite a focus of attention, not only because of the Competition Appeal Court's judgment, but also because there are proposals to amend the Competition Act, and particularly the predatory pricing provisions. I think the precise scope of the amendments is not clear at the moment. There has been a draft bill published, but I think the amendments will obviously pay careful attention to the current state of the law as set out by the Competition Appeal Court. And Neil's going to be looking at the topic in the context not only of traditional predatory pricing, but also the context of the new economy, if I can put it that way. Given that this is really a very detailed economic subject, I'm just going to ask Avias to make a few introductory remarks, and then Neil, over to you, and then let the debate begin.
Thank you, Anton. Neil, I guess as a starting point, it's well noted that in recent years we've seen an increasing focus by competition authorities on platform networks, which are essentially two-sided markets. And I think this is true particularly when one looks at what's happening in Europe and in respect of firms like Facebook or Google or Amazon, where they're faced with two groups of customers. They have viewers or readers on the one hand who are receiving product at very low to no cost at all to them. And on the other hand, you have essentially publishers, or you've got advertisers who are paying a pretty penny to access those readerships and those viewers. So you essentially have what we often in economics term network effects. Now, an important feature of these big tech firms is that they often have very high fixed costs and sunk costs, whilst having very little to very, very small marginal and or variable costs. And this makes it very difficult to conduct price cost tests. And indeed, similar observations have been made by the South African Competition Tribunal as well as the Competition Appeal Court in the recent Media 24 case in which you were involved. Now, I guess the big question that we have, and what we'd like to talk to you about today, is this. Given how we understand traditional predation price tests work, do we as economists and policy practitioners need to rethink some of these tests that we apply when looking at big tech firms? And if so, what is, in your view, the approach we should be taking? So I'm not sure if you have any thoughts on that, but I think I'll hand over to you now.
Okay, thank you, Anton. Thank you, Avias, and good morning, everybody. So I think, this is a topic which I think is extremely of the moment, as Anton mentioned, because we have the Media 24 judgment quite recently produced, and as Anton also mentioned, that has put the predation provisions of the South African Competition Act sort of under the microscope, with the potential that they could be amended. Now, yes. Rather than sort of trying to answer Avias's question up front, I think the way that I would like to deal with it is hopefully allow my answer to that to kind of emerge over the next 40 minutes or so as we discuss this topic. Because I think the answer is quite involved, and I'd like to just introduce some principles and a bit of a story about how the legal test has evolved to try to kind of bring us to a point where I can answer that question hopefully coherently. But just to give a kind of upfront flavor of what I think of what the answer will be, I think it's quite important to recognize that although new economy cases, big tech platforms, etc., have their own particular characteristics, the set of principles for assessing predation shouldn't really change going from old economy cases to new economy cases, or going from industry A to industry B, and so on. Indeed, from my perspective, an alarm bell almost always kind of rings when somebody tells me that their particular arguments or approach is somehow industry specific because, inverted commas, this is a unique industry. The underlying fundamental...
Neil, I thought every industry is unique.
Well, exactly. That's why the alarm bells never stop ringing. But I think it's a little bit of a warning sign when you hear that maybe the arguments that are being deployed are somehow a bit customized and a bit bespoke to the situation, where really what we're all looking for, I think, as lawyers and economists and judges and ultimately lawmakers, is to have some underlying principles that actually work in all contexts. And that's what I hope to just explore a little bit this morning, and then come back to Avias's question at the end and try to explain why I think that if the basic principles that are adopted are correct, they are ones that can accommodate new economy type problems. And again, just to anticipate a little bit where I'm going to go with this, I think the Media 24 approach of the Competition Appeal Court doesn't give that flexibility, because in my opinion as an economist, it lands on the wrong principles. Whereas I think some of the amendments that are currently being under consideration would, by contrast, lead to a framework that would be better suited to handling these kind of new economy problems. So that is to give a flavor of where I expect to hopefully take us. So with that, Anton, Avias, I'm not sure if you'd like me to move into the slides, or if there's any other upfront questions.
I think let's get into the slides, and then we will raise questions, as and when they come up.
Super. I've got a few slides to begin, just to introduce the topic. So, first of all, on slide one, I think it's helpful just to, as a starting point, before I get into the economics, just to give a quick outline of what the legal test of predation is, sort of on the face of it. But I'm then going to explain that there's quite a lot of subtlety to actually how these tests are to be interpreted. Now, of course, when we think about a legal test of predation, the underlying policy concern is a concern to balance so-called false positives and false negatives in an appropriate way. So, by and large, low prices, aggressive competition, the desire on the part of one company to beat their rival and send them packing from the market is all, in general, good and likely to promote consumer welfare. Only in very rare circumstances is conduct likely to be exclusionary in a peculiar way, namely that it's anti-competitive and gives rise to consumer harm, and then would fall within the definition of predation. So when we think about the design of any rules or principles for identifying predation, we need to be very careful that false positives, in other words, falsely classifying just aggressive competition on the merits as predation, that those errors are very few and far between, and potentially be somewhat more tolerant of false negatives, which is that on occasion some predation may escape detection. So, because taken together, that is ultimately going to promote the consumer welfare to the highest extent. So that is the general kind of starting point, and I don't think that is particularly controversial. The question is how to then give effect to that through sort of systematic principles.
Neil, just to state an obvious point, predation, as I understand it, certainly in South Africa, only applies to pricing conduct by a dominant firm, and I assume that's one of those the first gates that one has to get through along the policy line that you've identified.
Indeed, that's quite right, and you're absolutely right to point that out. And something that's maybe worth mentioning is that, and Anton, you might sort of correct me here, but my understanding is that the dominance gate is one that is more easily passed through in South Africa than in the EU, because you essentially have presumptions of dominance, roughly speaking, at relatively low market shares. So if your dominance hurdle is a lower one, then arguably that would give a reason to be more stringent in your subsequent predation test, because the risk of false positives would be greater.
Yes.
So I think
No, that's absolutely right, Neil. And just to be technical for a second, the dominance test here is a market share of 45% irrebuttably presumed to be dominant, 35 to 45 rebuttably presumed to be dominant, and then below 35, essentially the complainant or the commission would have to show that the firm has market power.
Indeed, yeah. So then, sort of recognizing the point about being very, very cautious about the identification of predation, we then move into the tests. So the EU test for predation, which you do not find in the statute, it comes from precedent, and in particular from the AXO case, is in effect that pricing below average variable cost will be assumed to be predatory, and setting your prices between average variable cost and average total cost will be viewed as potentially predatory if it is also in combination with what I've called here intent, and the more complete version of that is quoting the precedent, part of a plan for eliminating a competitor.
Yeah.
So that's the kind of the EU rubric, but as I will be explaining in the coming slides, it's not quite what it appears. The South African Competition Act, by contrast to the EU, actually writes the cost test into the legislation. And that was fundamentally important in Media 24, and we'll come to that as well. So the 8D4 provision is that a price below marginal cost, or AVC, is likely to be viewed as predatory. And then there's the 8C provision, which is essentially a catch-all type of provision. So you could essentially try to argue predation within that limb on a different cost standard. So that, I just wanted to kind of raise this at the beginning, as it were, as the sort of the very basic legal starting point, and then go a little bit into the economics, and then come back to the legal tests and see how they've actually functioned in Media 24 and the nature of the amendments that are being proposed.
Yeah. No, perfect. Thanks, Neil.
So, from an economist's point of view, and this is, perhaps a statement of the obvious, but from an economist's point of view, when you have a predation case, it's important that it's not just a sort of formalistic type of exercise of somehow demonstrating that the tests that I've just described are satisfied, but that in economic terms you have what you could call a theory of harm. So really a kind of a coherent end-to-end story about the nature of the conduct and how the conduct gives rise to exclusion, and in turn how that exclusion is going to harm final consumers. So the first thing that has to be made very clear in a predation case is being specific and precise about what is the predatory act. And in a textbook, the example that you will normally find is just selling some units of output below cost. So if I'm a widget supplier and it costs me, 10 pence for every widget that I make, but there's a rival trying to enter the market by winning some of my customers, and for those customers I start selling my widgets at 8p, so below the cost of 10p. That would be a sort of textbook example of predation. I think what's quite striking is that not many of the predation cases that you actually find in the precedent, and by the way, there aren't that many predation cases in the precedent, but of those that you find, not many are just quite as simple as that textbook example. So, for example, quite a lot of the cases that we have concern transport markets, and the concern is launching products or services on routes below cost. So the examples there would be in airline competition, putting an aeroplane on a route where you face an entrant, where running your own plane on that route as the dominant company is loss-making. Or in the UK, we have a case, Cardiff Bus, where the dominant company was putting kind of extra bus services on routes in much the same fashion. And you can kind of instantly see that when you're talking about deploying a plane or running a bus service, that's going to bring in some sort of fixed costs that are intrinsic to the operation of an extra service, an extra route, etc. So we can already see that if those kind of acts, if that kind of conduct is to fall within the ambit of predation, we can almost already see that the average variable cost test isn't necessarily going to be very satisfactory, but we'll come back to that. The next one on my list is sort of the opposite of the one I've just described, which is not launching a product that's below cost, but it's actually failing to close down a product or service that has become loss-making, and where the only reason for continuing to operate it is because it serves some sort of exclusionary purpose of preventing an entrant coming into the market. And that, in fact, is the Media24 example. So there was no suggestion that in launching the Forum newspaper, sort of back in the day, that had been a predatory act. The conduct that was the impugned conduct was to say that continuing to run Forum over a long period of many years when it was loss-making was not normal business conduct, because normal business conduct would have been to close it down. It wasn't washing its face anymore in a commercial sense, and the only reason that it was kept there was as a kind of predation vehicle against the entrant. As far as I know, Media24 is the only case that falls into that category of sort of failing to close down a product.
Sorry, Neil. I think the other one I can think of is Aberdeen Journals.
Yes, I think that was a slightly different one of using. There was a main newspaper and a sister newspaper, and then it was using very aggressive pricing on the sort of sister newspaper as a sort of fighting brand against an entrant. So I don't think the suggestion there was that they should have closed the other paper down. It was that it was being used as a fighting brand with very aggressive pricing.
Sorry, can I just butt in for 2 seconds there, Neil? Because I think it's very important to think about, if you are a dominant firm and you're now being advised that, there are various sort of forms of conduct which could land you foul of a finding of predatory pricing. I think that the big question that we're often faced with is, well, how do we react to competitors? What can we do? When a competitor enters a new route, or they bring on, if we think about airlines, you have a low-cost operator who enters a particular route, and I'm the large dominant airline who doesn't have a low-cost offering, and I now introduce a low-cost offering to in my view, meet competition. Where does that line get drawn?
Yeah, I mean, I think one way of answering that question is imagine the entrant then hypothetically withdrew their service. Would the dominant company then continue to offer the service that it has introduced, or does it kind of immediately remove it? So if the only reason that the dominant company is, in the airline's case, running a plane on another route, or in the Cardiff bus case, running the low-frills bus service, is to deter the entry or force the exit of the incoming competitor, and then having served its predatory purpose, that new service is shut down. Then the new service was run with entirely with a predatory intent and with predatory effect. But of course, in saying that, you can instantly see that the assessment of that is potentially going to be quite a lot trickier than just saying somebody was selling a few widgets at the margin at 8p when their marginal cost of production was 10p. It's a more involved assessment.
No, I definitely agree with you, and I think you touched on the point of intent, which we're going to get to very soon. But I think that's a key issue, particularly from a South African perspective. Yeah.
So I think just in the interest of time, let's go on to the next slide. The key point that I really want to make about the relevant costs is that the relevant costs should flow from the theory of harm. So they should be the costs that are relevant to the alleged predatory conduct. And what I explain here, which is going to be very important for what comes later, is that, as we know, the South African Competition Act, as it currently stands, writes the average variable cost standard into the legislation.
Yes.
But this may be a bit of a surprising statement to those on the call, but average variable cost isn't really a very meaningful economic concept, because it's almost a bit of an empty concept as soon as you start to think about it. So if I say, what are your variable costs, you might quite rightly ask me, well, variable with respect to what starting point? Should I assume that I'm already in the market, or am I an entrant into the market? And you'll get different answers, because if I'm not already in the market, costs I incur to enter the market are variable with my operation in the market. You might say, well...
Just to clarify one issue, I mean, when we talk about variability in this context, we need to differentiate between what a client may see as being variable from an accounting perspective and variability from an economic perspective, because I think that's where a lot of individuals get confused, because they think about variability in an accounting sense.
Yeah, I think that's absolutely right. So if I look at a set of management accounts of any business, I might see a heading that says kind of variable costs, and then, for example, all labour and staff might be put under variable costs, and then I might have fixed costs. Or even if exactly those headings aren't used, something like it might be used. So, I might have a kind of gross margin, and then, various other kind of margin concepts that are approximating this. But the way that costs are classified in management accounts on some sort of notion of variable and fixed isn't necessarily going to bear a particularly close relationship, if any, to the costs that are variable with reference to the predatory act. Selling a few more widgets or, entering with a new bus service or a new airline or keeping a newspaper open where the allegation is it should have been closed and etc. So that's exactly the problem. And when I'm thinking properly about the theory of harm, I want to know variable over what number of units, variable over what time period, variable in what kind of circumstances and etc. And the fact that variable costs are a bit of an empty concept when you kind of think about it, and a bit of an unsatisfactory concept, has led economists to prefer the notion of average avoidable costs. And I'm quoting here Baumol, who's really a sort of founding father, if you like, in this kind of area, saying average avoidable cost, not marginal cost, is crucial in testing predation. And again, we'll come back to the South African Act at the end, but Baumol here is saying, in effect, the South African Act, because it references marginal cost and not average avoidable cost, it's got sort of the wrong, arguably on his view, it would be that the wrong cost standard is written into the legislation. And then Arida and Hovenkamp, who are also very key people in this area, are saying average avoidable cost, they take a slightly different attack, but the underlying point is the same. They're saying average avoidable cost is not a different measure from average of variable cost. Rather, it should be viewed as a more precise way of determining which costs are fixed and which ones are variable. So they're really saying, rather than just have this rather undefined notion of an average variable cost, you ask the more precise question: if you didn't sell the units or run the bus service or operate the airplane on a given route, where that's alleged to be predatory, if you didn't do that, what costs would you avoid from not doing so? And that is the relevant costs for then comparing to your revenues and figuring out if it was predatory. So if you look at...
Sorry, I'm not jumping the gun here, but when you think about the approach that was followed by the CAC and Media 24, I mean, it's clearly one which differs from this view, because that approach essentially reads the Act into being and says you need to look at variable costs and not average avoidable costs.
Sorry, if I could just defend the Competition Appeal Court. Obviously, the Competition Appeal Court is saying that's what the current state of the law is, because that's the way it is. Yeah. But Neil, if I understand correctly, what you're saying is where average avoidable is helpful is to use the analogy you were using just now. If I weren't to publish this newspaper, what costs would I avoid by not publishing it, as opposed to what is my average variable cost for publishing it?
Exactly. And also going back to Avias's introduction at the beginning, where he mentioned in the new economy that fixed costs could be very large and marginal costs could be very low or even zero, you can see that a kind of a sort of literal or formalistic reading of average variable costs might tell you, well, very few costs are variable in a kind of management accounting sense. But as soon as you have the concept of avoidability, you can see that, if, for example, I'm not sure, a sort of big tech company launches a new app, for example, and the allegation is that was a predatory act, then the fixed costs associated with developing that app could fall within the definition of avoidability. So it broadens the concept. So what's happened is that although a couple of slides ago I indicated that the ACSO precedent in the EU does refer to average variable cost, what's essentially happened in the UK and the EU is that average variable cost has been just construed more broadly as encompassing average avoidable cost. In line with the Arida and Hovenkamp quote here, saying actually, average avoidable cost is just a more precise and better version of average variable cost. And essentially, that's what I failed to persuade the, I succeeded, I suppose, in persuading the tribunal, but ultimately the CAC rejected, and it took the view that average variable cost was something distinct from average avoidable cost, and that was what was to be found in the legislation, and therefore that was what had to be applied within AT4. So that's where we get this kind of disjoint emerging between the way it's done in the EU and the CAC.
And Neil, just to, I think there are many places in our Act where principles which were developed overseas, sort of more interpretively by courts, were then captured. I'm thinking of Section 4.1b, the cartel provisions, where those have been captured in the Act, which does make our Act slightly less flexible, I think. Yeah.
And by the way, you can, it's not it's not completely obvious that I would say that the South African approach is wrong, because it's all about balancing these false positives and false negatives. And in truth, I think no one really knows the relative costs. And I think, again, anticipating a bit what I'm going to come to towards the end, although average avoidable cost is a better way of specifying the cost standard and should allow for identifying some predation cases that otherwise wouldn't be missed, it also risks more false positives, because it is a more expansive concept, and therefore if it's kind of badly applied, either by economists or by the administrative authorities or by the courts, and if dominant companies are kind of worried about the misapplication of this concept, it can have exactly the effect we don't want, which is that pro-competitive behavior gets condemned, and dominant companies may sort of also refrain from pricing as aggressively as we would like them to. So, I think what I'm trying to... Yeah.
So, sorry, Neil, I was going to say, I think that's one of the points that the CAC did make in their judgment, is to say you don't want to undermine innovation, and you don't want to undermine the ability of large dominant firms from cutting prices and offering consumers better priced products.
Yeah, understood. Okay. Shall we just very quickly sort of crack on and go on to revenues? Because I think the reason I mentioned revenues is that in predation assessments, revenues sort of end up being the sort of poor cousin of costs, because I think it's kind of well understood that measuring costs is tricky and controversial, and there's different ways of doing it. But what can maybe be more easily overlooked is that assessing revenues is not necessarily a straightforward task either, and that again is something that came up in Media 24. And what I mention here is really sort of two approaches to assessing revenues. The first is again more of what you could call a sort of management accounting approach, where you look at the product that's being sold that's alleged to be predatory, and you just see what its revenues are. And you compare that to whatever the costs are to see if they're below cost. The more subtle approach is, for example, when you're running in Cardiff Bus, running the no frills bus service, or in airlines, you're running an extra airline, or etc., is not to look at the revenues generated by that service, but to look at the incremental revenues generated by that service. Because some of the revenues of that service may just be cannibalizing the revenues that the dominant company would have been making anyway on its other services. Yeah. And of course, this was an issue that came up in Media 24, where the question, the alleged predatory product was Forum newspaper, and the question was, should we just be taking the Forum revenues, sort of as they appear in the management accounts, or should we be taking into account that actually if Forum didn't exist, some of those revenues would revert to Media24's other title, Vista. Now, I'm afraid that, in my opinion, Baumol is rather sort of misquoted in the CAC's judgment, and some important points from Baumol sort of not mentioned at all. But his position, and I think it's the right position, is that from an economics point of view, at least, if a given product or service is being alleged to be predatory, you want to compare the incremental revenues that it generates with the avoidable costs that go with that product.
Yes.
Again, you can say, well, that's all very well as a matter of economics, and we might all actually agree that strictly that's the right question. But you might rightly say, but hang on a minute, that's making the analysis even more complicated, and even harder for the authorities in the courts to assess, and harder as a consequence for dominant companies to anticipate when their conduct will be deemed legitimate or not. So again, you have the economics on the one hand, but you have the question of providing a kind of a comprehensible regime on the other, which is why this is all, I suppose, in the end quite quite interesting and quite controversial. But I just wanted, at least for today's purposes, to mention that the kind of total revenue versus incremental revenue issue can be quite significant. I think in view of time, we can maybe just skip over this multi-product slide, Avias, if that's okay. And if you just, so two-sided platforms, so I think we're all familiar with two-sided platforms, which essentially involve, two user groups of the same product who are kind of linked by externalities between each other. In other words, sort of the users of one type are benefited by the existence of users of the other type, and so forth.
Yes.
Now, this is not kind of something that didn't exist before the new economy. I mean, on the contrary, these local newspaper cases are kind of old economy cases, but they are, newspapers are two-sided platforms, because the more readers there are, the more attractive the newspaper is to advertisers. And that explains, for example, why you can give newspapers away for free to the readership, because you can recoup on the advertising side. And the basic point here is, therefore, that whenever you're dealing with a two-sided platform, simply observing that the price is below cost on one side of the platform doesn't imply that the predation test has failed, because you need to take into account the fact that the value that's generating on the other side of the platform. So, this is two-sided platforms. More generally, I think just complex monetization mechanisms, if I can put it that way, are not new to the new economy, but are certainly prevalent within the new economy. So if one was assessing predation cases in relation to new economy business models, taking into account that they may well be two-sided markets or have complex and indirect routes to monetization, all of that obviously has to be included on the revenue side, otherwise there's a risk of falsely identifying predation.
So in other words, Neil, one must be careful of going back to what you said at the beginning of saying new economy, new rules, this is different. Actually, It's the same principles. You just need to apply them, and it's obviously the detailed costing and those calculations which might be different, but the principle is still the same.
Exactly right. Now, I think, Avias, you mentioned intent sort of at the top in your introduction.
Yes.
And let me just kind of touch on this briefly. As I also mentioned at the beginning, the AXO precedent in the EU says that a price between average variable cost and average total cost in combination with evidence of intent, in other words, being part of a plan to eliminate a competitor, may be viewed as predatory. And most economists struggle with that because of two reasons, really. A price above average variable cost is a price that makes a contribution to joint costs and is therefore incrementally profitable. So there's nothing particularly suspicious about a price that's above AVC but below average total cost. And secondly, having intent to eliminate your competitor is what competition is all about. So there's nothing particularly suspicious about that either. So economists are very skeptical, I think it's fair to say, about the idea of the second limb of the AXO test in Europe. My position, which I sort of tried to explain in Media 24, and which isn't really reflected in the CAC's, doesn't really come through in the CAC's judgment, is the following. I think is the following idea, which I think is good in concept, although again I recognise may be quite difficult to implement in practice, which is, if I have a price, let me start again. If the intent isn't just intent to eliminate a competitor, which is fine, but is intent to compete against this competitor without regard to whether my own product is profitable or not. In other words, I just have an absolute commitment to eliminate this competitor, come what may, which includes running at a loss. And if the court believes that costs are between AVC and ATC, if the court finds that costs appear to be between AVC and ATC, but they cannot exclude that maybe they're below AVC, just because it's very, very hard to measure, that could be grounds for finding predation. Because in those circumstances, the court would be saying, well, here I've got a dominant company where clearly they had the intent to compete below cost, if that's what it took. And the cost measurement is very difficult. So although the cost appears to be above AVC, I can't rule out that it's below AVC. Therefore, because of its intent, the dominant company kind of doesn't benefit from the benefit of the doubt, and there's enough there to reach a finding of predation. Now, even as I say that, I realize that comes across as quite convoluted. But it's the only way as an economist that I can make sense of intent, that it has to be intent to incur irrespective of making a loss, which may then give a court the confidence to reach a predation finding, because it believes that even though the cost measurement is difficult, it at least sees that that may have been what occurred.
So in other words, I mean to do it, and because there's evidence that I mean to do it, that helps the court to forgive the fact that I can't show it. Precisely. And I readily take the point that might ultimately not be capable of giving sufficient legal certainty to be attractive. But on the other hand, I raise it because it's my best attempt to put intent on a proper footing and make some sense of it. Because I think the naive version of just plan to eliminate a competitor doesn't make any economic sense. So it's my best effort to resurrect intent. Whether that's good enough or not is a different question. Yes, I think the problem is many people intend things which they sometimes don't know whether they can achieve, and also sometimes intentions are expressed incautiously without necessarily knowing precisely what they.
I think sometimes it's also interpretation after the fact, which is always difficult.
Indeed. Although one of the features of these predation cases is you get extremely flowery language about the dominant company putting its foot on the throat of the rival firm until it's starved of oxygen. That's Aberdeen Journal's Media 24 wanted to see the Golden Night News taken to the church I assume, in a common. So there's, but then you have to look through that and see, what does that really mean? Was it a sustained intent to set a price below cost, a willingness, an intent to incur a loss, and then that would kind of fall within this version that I've given. So I'm conscious that we probably only have a few minutes left. So I wonder if I can sort of begin to wrap up a little bit by just quickly drawing some threads together.
Yes.
So I think in the Media 24 case, I think we've already touched on this, but the CAC said very clearly that AVC has a specific meaning distinct from average avoidable cost. So they were rejecting the Rita and Hovenkamp quote that I gave you, that actually AAC is just a better rendering of ABC. It's making the same concept kind of more specific and precise. That was rejected. And then the way that the CAC saw average avoidable cost fitting in is it said, well, that could go into the 8D assessment, but the 8D assessment cannot and should not accommodate the idea of pricing below ATC with intent.
Correct.
So where you end up with is 8D4 is kind of narrower than the first limb of the European test, and 8D is kind of equivalent to the first limb of the European test, and then there is no...
8C, I think.
8C,
Neil, I think you're referring to 8C.
Yeah. There's a typo. I apologize.
Sorry.
And then there is no scope within that rubric for the second limb of the European test. So essentially the whole South African approach then becomes kind of one notch stricter than Europe. However, this is a moving story. So I think Avias was now just going to quickly refer to the proposed amendments in the Act.
I think, Neil, maybe if I can just touch on those very quickly, because I think that is really a moving feast at the moment. So there has been a bill which has been published, but I think that is likely to change. It hasn't been introduced by the Minister into Parliament yet. But I think it's likely that the amendment, whatever it ultimately is, will take account of the debate that was had in the CAC between, is average variable cost a concept which is different to average avoidable cost, and what is the better metric to adopt. So I think it's going to be interesting to see what ultimately happens there. But I think the whole way it's going to be trying to balance the point that you started with, false negatives and false positives, and what seems also to have actuated the CAC's cautious approach, which is one doesn't want to over-deter, and by doing that actually decrease consumer welfare.
Yeah.
I think I just had one question for you, Neil. I mean, just reading the proposed wording, which is seeking to introduce average avoidable cost as well as long-run average incremental costs into the definition. I mean, is South Africa trying to come into line with their global counterparts, or do you think South Africa is falling into the same trap or potentially falling into the same trap of explicitly naming cost measures within the ambit of the Act?
Well, I think it's probably both. I mean, certainly this revised wording would bring the South African Competition Act into full alignment with the EC guidance on assessing exclusionary conduct. So you would get full alignment. But yes, query whether there's a danger in ever writing the cost standards into the legislation, because you then sort of get locked in, and insofar as approaches evolve, etc., over time, that becomes more difficult, and then that's kind of trade-off between kind of certainty and flexibility. And I've got a lot of sympathy with, I mean, economists normally always go on about, how it's nice to have flexibility and etc. I mean, I have quite a lot of sympathy for the notion of certainty as well, to be honest, putting yourself in the shoes of a business. So, but on your first question, there's no doubt this would represent alignment.
And then I think the last slide, just to round up, looks at strategic considerations for defendants and as well as for claimants. I don't know if you just want to touch on that before we finish off.
Yeah. So I think, just in a nutshell, it's maybe worth saying that, predation cases are few and far between. So, putting together Europe and the US and many decades, there aren't that many predation cases. So, and I think also normally, companies ought to be pretty aware that they are predating when it's actually happening. So all the cases that I'm aware of have involved extremely aggressive sort of internal documents and a commitment really to compete irrespective of cost, etc., to exclude typically a kind of new rival. So in other words, I think it's a bit hard to predate by accident.
Yeah.
Although that might be a bit different for, say, big network industries or kind of former national state monopolies, telecoms companies and etc., where in those big network industries, it may be easier to predate by accident just by having prices in some part of the network below incremental costs. But outside of those examples, I think generally it's a bit hard to predate by accident. I think the points I'm just making here is, on the face of it, the Act, it says, predation is priced less than average variable cost. What I've tried to illustrate a bit today is that it's a bit more subtle than that, and everything should really stem from thinking about what's the allegation here. In other words, what's the theory of harm, and then what's the kind of rational concepts of cost and revenue to assess that theory of harm. And just one final point. I think, but repeating myself a little bit, I think the amendments to the Act are either, if they're rejected and the CAC approach stands, the South African approach to predation will be narrower, I think, than in the EU. If the amendments are accepted, there will be alignment, but with alignment comes more risk of false positives, and because the concepts of average avoidable cost and etc. are more elastic, perhaps, and need to be more carefully applied, and are more complex to apply. So, so I think we stand on the cusp of one of those two outcomes, and which one eventuates is going to have some implications, I think, for how companies think about assessing their own conduct, and also the chances of being successful if you're a complainant, if you think you're being predated against, the chances of getting a predation case across the line, which is actually not that easy.
Neil, so maybe putting it slightly differently, as we were talking earlier about, there's the gate you have to go through, which is prove dominance on the part of the allegedly predating firm. But the second thing is a practical gateway is also going to probably be that you at least need some internal documents evincing an intention. It's not good enough, but it's probably going to be those cases where the authorities are going to be most focused. Coming back to your point, it's not going to be a mistake. They're going to be looking for that, and then finally the numbers to back it up.
That's right. I think in most cases the authorities are going to be looking for well-evidenced kind of end-to-end story where sort of everything stacks up in terms of the unusual conduct, the exclusion, the consumer harm. You need to, for a complete story, you need to understand why, when the predation finishes, the excluded firm can't just re-enter the market. So, whatever the legal test is, I think most authorities are looking for a fairly convincing end-to-end story that squares with all the evidence, the economics, the witnesses, the internal documents, and etc. With the possible exception of the sort of big network utilities, I think, where there's a risk of just low pricing on bits of the network could result in exclusion.
No, fantastic. Well, Neil, thank you very much to both you and Avias for leading the discussion. There aren't any questions at the moment, so I think on that note we will end the session, the debate. And again, Neil, thank you very much.
Thank you very much. Bye, everyone.
Thank you. Bye.